A very good afternoon to one and all. Today we have with us Advocate Nivedita Mullerpattan, founder of Volant Legal, practicing at the Bombay High Court. We are going to discuss issues and concerns related to tenancy, rentals, and also the issues facing the COVID-19 pandemic from a legal perspective. Firstly, I would like to welcome Advocate Nivedita Mullerpattan to our YouTube channel today.
Thank you. Thank you, Dr. Edmond Fernandes. I'm really pleased to be here. It's a good experience. And in quarantine, I believe it's a good chance or opportunity for me to actually give out this opinion or advice or whatever you may call, which might help at large. So
Okay,
thank you for this opportunity.
So let's get started then. My first question to you would be, this pandemic has created a lot of confusion in legal interpretations at large, as courts are not functioning properly. Selected courts are going for video conferencing. So what is the way of justice forward, or what is the way you see recovery as a new normal, which the court of laws will start to practice now, and which advocates practicing such as you would now start to adopt?
Look, I feel that right now this is a very temporary phase. Of course, this phase has to evolve to a new normalcy. I agree to that. But right now, I feel people are getting a little impatient also to understand what is the way forward and how do I get justice, etc. So, courts are doing their best in the sense video conferencing is already available. Wherever there is a very urgent matter, the courts are working. There are judges sitting. What is not happening is the regular boards are not functional. But in case if there is an emergency or you want to move a matter, it is happening. People are moving matters. In fact, recently there were webinars given by Honorable Justice Chandrachud, D.Y. Chandrachud, and Honorable Justice G.S. Patel in Bombay High Court and Supreme Court. So Supreme Court is already designing a portal where they can shift to an online operation altogether. They are Bombay High Court is now operating with a mix of their own portal and other portals which are there. This pandemic has suddenly come, so it is going to take a little time to adjust to these things. Along with the court, I feel even we as advocates or the litigants have to have patience, have to be ready to adapt this change towards this digital evolution. So everything is going digital. So of course there will be a part of court which will be working digital also going forward, even if there is no even if we come out of the pandemic safely. Even after that, I believe there is going to be a combination of video conferencing, online filing, plus the physical courts, which I think is a good thing. It is going to help us in a lot of ways. So it's just that we stay patient and don't get impatient about it, and we will get justice. Whoever is in need of justice today, it is there, it is available. We can do online filings, everything is available. So I don't really see a confusion. The confusion is only that people have to understand what it is.
Reminds me of the fact that justice delayed is justice denied. So probably that's why a lot of people who are already scared, worried, would want the court of law as one of the pillars of our constitution to fast track their transformative processes. That's my inherent feeling.
Yes, yes.
Coming to the issue, a lot of people these days have abstained from paying rent, and a lot of tenants who are residing in housing societies, in taking shops on rent, have now started to willfully default. This is making it very difficult for landowners, landlords to pay their dues and clear their payments, because it's an ecosystem which is now paralyzing things. What would you advise as the way out? I mean, even people who have money are willfully defaulting. How do we address that?
Yes. So, first of all, this is a situation where everybody is affected. Not only landlord, even the tenants, even the rentals. But yes, the recent confusion that happened is because people were not clear what to do in this situation. The government passed an order because there were huge people migrating from one place to another because either they didn't have place to stay or because of the rental problems, they thought we will not be able to pay the rent, and therefore that might have added to the reason, right? So to curtail that, the 29 March order was passed by the government where it said that it may be postponed. No landlord will ask for any rent for a period of 1 month from these people. This was only to establish that, to make sure that people are not moving out or taking any drastic step in the time of this pandemic. So right now, what we need to understand is our rights are not going anywhere. A tenant will owe rent to a landlord, and the landlord will get his rent sometime or the other. What the government was trying to do is just pause it for this moment, just pause the right, not take away the right from them, but just for now, they were saying don't demand it because they have nowhere to go. They can't come out and go anywhere.
So
So right now,
basically, meaning to say that you give them some flexibility in terms of a month or two and
yes.
then recover it later.
Yes, that's correct. So if you see in USA also, they have passed this law saying that you will not, for some, they have put some caps and all. I'll just generally say, I'm not going to the details. But generally it is said that you will not vacate anybody. It's the same purpose. Again, the rights are just paused for that moment, but they are not taken away. After the pandemic, whenever they are in a position to pay, of course you will get your rents, right? But at least in this state of pandemic, the government or we as people should understand that we don't create new legal issues which is difficult to be dealt with, especially at this time when the courts are also looking for a way forward to function, etc. So we shouldn't put that load also on the courts. So the best thing is maybe you can talk to your tenants. So if I have a tenanted premises, my office premises is on rent. So it was very nice of my landlord also to understand the situation. I was also understanding. So we came to a mutual understanding, where I paid the rent till I could, or whenever I am not able to, I told him that I'll hold this and I will give it to you the next month or something. So, I always think that people can sit and talk about it and come to a solution instead of panicking and thinking that their rights are going away or they are not getting the money or something of that sort.
Okay, I mean, yeah, that's a very nice solution indeed. But how do you feel that landlords should really deal with tenants who invoke the pandemic as an excuse to default? I
See,
mean, in a diverse country like ours, we do have people who are upright and straightforward saying, okay, X amount I will owe you now, X I will owe you later on. But people who even have the money and say, you know what, government has passed an order and media is also saying you should not pay. So how do we really come clean on this to rectify and differentiate between what is the actual order and which is the interpreted order by people for their own convenience?
see, first of all, what people are interpreting is not really important. The fact remains that what the order is. So the order is not taking away the right. This the landlords also have to understand. The tenants also have to understand that if not today, tomorrow this money will be recovered from you. So this is just a relaxation time where people are getting laid off. Actually, people are getting, so there are percentage of people who are really affected also, and in that I understand there might be people who are trying to take undue advantage of the situation also. It's always a mix. Everything has a negative and positive side to it. But if we see the larger picture, I don't feel that the landlord should right now rush to the courts. And even if you see Bombay High Court, recently there was an order. The Bombay High Court said that this order already says, the 29 March, that you can approach the government in case of any difficulty. So you don't really need to go to the court at this stage. You can either sort it out between yourselves, or you can go to the helpline in the order, whatever the order says, wherever you can go to the government authorities and get it sorted, or you can just wait for this period, and when the lockdown is lifted, when you are given the opportunity to approach the court, you can then approach the court and recover your rental amount from that person. So it's not that your remedy is gone, it's just kept on hold for a little while, and you can obviously go to the court and recover these amounts.
Okay. And do you think the police have a role to play in the rental and tenancy issues if you have a tenant not willing to vacate the house, invoking again a pandemic, yet not paying the landlord? Because then you have that the space is being occupied, the payments due are not being paid, and yet now the courts are functioning at a lower scale. So not actively to the proportion at which it should. So where does the landlord go, and does police really have a role to play in this, or does it become a civil issue of sort?
Yes, so the police will not really have anything to do with the civil dispute which arises between the landlord and the tenant. That will be going to the court, as I said, whenever the regular board, etc., starts functioning full fledged. The landlord can always go and recover his amount. But for right now, and the police, as you said, it will not have any right in the civil issue unless there is any criminal act committed in realm of that civil issue. So if there is a fight between the two, or if there is any criminal act coming up, then the police can of course interfere and make peace between them, but it will be restricted only to that. Beyond that, the police doesn't have jurisdiction to deal with the civil issue.
So as far as Section 138 Notice of the Negotiable Instruments Act is concerned, and if check bounce becomes an issue, which in legal parlance at times people say it's a criminal case, so then does the police come in here, or again you have to go back to the court?
Look, 138 of Negotiable Instrument Act is a quasi-criminal act. It's not out of IPC or CRPC. It's out of Negotiable Instrument Act. So it's a quasi-criminal act. So again, there you have your remedy given in the act. You can approach the court and you can apply for the check bouncing thing and go through this process of court as it is stated in the act. So there is no really FIR or anything. The procedure is not as per IPC. There is a Negotiable Instrument Act, which is a separate act, which regulates this procedure. So you can follow that procedure. There is no difficulty.
For the benefit of our viewers, what would be some of the best practices you would propose for landlords keeping in mind a general rental agreement? Would it be meaningful to have an affidavit in the form of an undertaking signed by the tenants as a mark of commitment? Would that be a good way forward?
Right now, like I already said, I wouldn't encourage anybody to approach court right away, because the courts are also not in a position to right now pass orders regarding the pandemic unless there is such a grave situation that yes, you need the court's interference. So I would also encourage them to take some advice either from somebody who knows legal profession, from advocates, or just a mediator or somebody who can sort their issues out. A mediation, I think, is the best possible remedy at this stage. If the parties cannot make peace between them or come to a mutual agreement what to do in this temporary moment, then mediation is a better option, I feel, rather than moving the court. Because anyway, even if you move the court, it is going to take a little while, right? So it is in their interest that they come to a mutual solution between them or have an arbitrator, and like that they move forward. As far as affidavits are concerned, we need to understand what is the legal purpose of this document. So there is affidavit is a piece of document where you make truthful statements on oath. So if there is a wrongful statement made, if there is a false statement made, then you have action or remedy against that person who has made false statement in it. But affidavit is not a very idle document for an agreement between two parties. So it has to be in the form of an agreement, not really an affidavit for that purpose.
Got you. Uh, Mumbai, as such, has a lot of dilapidated buildings which are in the process or should have been demolished, redeveloped. Looking at it from a disaster risk reduction perspective, COVID 19 as a pandemic is a biological issue, but India as a nation state loses $10 billion every year due to disasters, especially natural disasters. Among those, Maharashtra is one of those high risk states by a UN report. So, what do you think can be done to safeguard these housing societies, both in terms of civilian protection, community care, and also to engage in safety and safe practices for people living in old structures wherein the government has still not taken any action over?
As far as these dilapidated or cessed buildings are concerned, we have our laws in place. So there is a Mahada Act. The Mahada Authority has three boards which function. One is the Mahada Board. Under the Mahada Authority, there are these three boards. One Mahada, one SRA, Slum Rehabilitation, and one is MBRRA. So this board, MBRRA, is for repairs and redevelopment of cessed structures in Bombay. So there is a special enactment of Mahada present here which deals with these cessed buildings, and this read along with the DCR, the Mumbai Municipal Corporation Act. So we have provisions given for a dilapidated building which is urgently requiring some repairs or urgently requiring to be taken notice of. So these laws are there. I don't feel there is uh, uh, it is not that there is no laws, but what you said is there is no action taken. I feel the implementation of these laws is somewhere uh, having a gap. So I believe the implementation should be improved, as you said. Plus, I would give 2 points which also the government is working on. It's not still in place, but government has given statements that it is going to happen. So first is the people staying in the dilapidated building have to be given a temporary accommodation. So Mahada already has their transit accommodations where they shift these people to. So they give them a temporary accommodation. The second question remains, what do you do of the dilapidated building? Now these people go to these temporary accommodations having a hope that I am going to come back to my home once this is redeveloped. But that redevelopment is not happening fast. And this is because there is no time bound regulation. There is no regulation or a provision which puts it in a time bound manner. So I feel it is the need of the hour that whoever take this responsibility of redeveloping a building has to be regulated by some provision of the law. Even RERA and MOFA are very vague whether they apply to a redeveloped building or not. Right now, it is not in the ambit of RERA and MOFA. So we are trying to interpret it and say that it is in the ambit, but there is no clarity of the law whether these regulatory laws are applicable to these redevelopment of cessed buildings. So I feel that is one thing. What there has to be a regulatory thing and a time bound manner. So people have to be accountable if they are making a delay. It is only then that these projects will happen faster. Today I see wherever I go, if there is a redevelopment proposed, the tenants are scared that, oh, once I go out of here, I am not getting my home in 10 years. This is the apprehension that the tenants are having, because of which there is a resistance. The tenants are resisting going to the courts. There is a huge surge in the court proceedings where these tenants are moving the court and trying to stop the redevelopment because of these apprehensions, that once I'm out of here, I don't know if I'm going to be back here and when. Plus, there are these old people who have saved their houses for so long, thinking that this is my old age home for me. And now if it's going for redevelopment, they are kind of insecure. So that is another problem there. So I feel that once it's made time bound and there is some accountability for the builders or whoever is taking that responsibility, it is going to be much better. Having said that, the government is implementing, like the self redevelopment program has been introduced. So now, subject to those laws which are passed, the circular or whatever, there can be a self redevelopment by the people of, by the tenants of the society, or plus the government is thinking of implementing model tenancy laws, where they are all these old pagdi system people who are paying very less, and therefore the landlord did not have the motivation to repair the building because he was not getting or hardly getting any money out of these people. To address that issue, the government is proposing that in model tenancy laws they will make the rent of even these people equivalent to the market price. But again, this is a place where the competing rights of parties have to be balanced out. It can't be one sided. So the government has this responsibility also to balance out the both the sides. So if they say that it will hike to suddenly people paying 800 rupees as rent will have to pay 50,000 or 1 lakh, it is going to be very impracticable or very difficult for them to do that.
That's true.
So the government is coming up with laws which will probably, and let's hope that will balance out the rights between the two parties. So the laws are evolving. I feel in the coming years, or in the coming times as it evolves, we will have better laws and better implementation of all of this.
Sure. Winding up our conversation, what would be those few selected reforms you think must be factored in at the national stage towards rental acts and tenancy in general? Some key points which you would recommend.
Yes, these are two very important points which I just said, that there has to be a time-bound redevelopment program. So it can't be perpetually, or it can't take 10 years and the redevelopment has still not happened. There has to be a time prescribed in the act. Secondly, there has to be accountability. There has to be some regulatory act which governs the builders or whoever is taking the responsibility of development. Right? These are two very important things which come to my mind and which is affecting the whole redevelopment process even after the fact that we have laws. These two things I feel is affecting the whole implementation.
Advocate Nivedita Mullerpattan, thank you very much for your time in conversing with us.
Thank you, Dr. Edmond.
Stay safe. Bye-bye.
It was very nice to be here. Thank you.
Subscribe to our YouTube channel and press the bell icon to receive latest updates and stories.